Committee. Around 5 minutes, please, Ms Adamson.
Thank you very much, Presiding Officer. May I firstly thank the CEEAC Committee members, the committee clerks and all those who submitted evidence and attended committee during our deliberations on this important bill. And it is a bill of profound concern. The committee believes, as a point of constitutional principle and simple democratic imperative, that Scottish Parliament should have an opportunity to effectively scrutinise the exercise of all legislative powers within devolved competence. The bill in its current form neither protects nor promotes that principle, nor does it encourage confidence when it comes to the potential impacts on policy areas as crucial and wide-ranging as food standards, animal health, safeguarding the environment, consumer protection, business practice and employment. Presiding Officer, there was a consistency in the evidence of stakeholders that you rarely find in parliamentary scrutiny. Even those witnesses who favour diversion from EU policy, both historically and for the future, such as the Scottish Fishermen's Federation, said on this it was more important to get it right than get it fast. The bill in its current form contains the sunset clause, and if its law is not retained specifically by either the UK or Scottish governments, it will automatically fall by the end of this year. Lorna Hood of the Faculty of Advocates said of the deadline, to put it plainly, we would end up with gaps in the law. The Society of Chief Officers of Trading Standards, among many others, shared those concerns. Scottish Environment Link referred to a much harsher cliff edge in devolved areas than reserved. The Delegated Powers and Legislative Reform Committee have also expressed serious concerns over this bill. Its House of Lords equivalent, Delegated Powers and Regulatory Reform Committee, stated that there is no certainty about the sunset provision itself because UK ministers can extend it under delegated powers in Clause 2. There is no certainty about which policy areas will be affected, and there is no certainty about what will replace revoked rule. Seafood Scotland said that the legal cliff edge would force businesses and representatives to divert considerable resource to understanding and responding to the proposed changes. The National Farmers Union of Scotland suggested the sunsetting of retained EU food law could well return us to a time when there was little in the way of standards applied. Let me be clear, Presiding Officer, witnesses were not opposed to the principle of reviewing retained EU law, but any review should not be driven by what Seafood Scotland called arbitrary cut-off dates. The Soil Association had, again, no objection to a sensible process of examining, updating or improving existing law, but we do not think that the bill as drafted delivers that. And given inflation, energy prices, post-pandemic recovery and the economic impact post-Brexit, you can but sympathise with the view of the Institute of the Directors that the bill is the last thing that business needs in a fragile economic environment. Presiding Officer, the sunset clause as it stands cannot deliver appropriate levels of consultation, scrutiny or debate. The scale of the task ahead cannot be underestimated, both in terms of additional administrative burden and the challenge of conducting scrutiny within the time constraints. This applies for stakeholders, for governments and for this Parliament's committee. I have already thanked my committee colleagues. It is to their credit that we have been able to work in such a productive and collegiate way this session. However, to note, we were unable to agree a unanimous support for this report with Conservative colleagues on this occasion. Presiding Officer, we cannot do justice to the report this afternoon, and we have indeed asked the Conveners Group for a committee-led debate to allow further discussion across committee interests, as this will impact on many subject committees of this Parliament. We have also highlighted the potential impact on the workload of the parliamentary committees going forward. We have written to Standards, Procedures and Public Appointments Committee and the requirement for a legislative consent motion in this specific circumstance, when consent is not to be laid by the Government through a legislative consent motion. Our standing orders are silent on this at the moment, and we therefore have requested a review of procedures, given, as the Cabinet Secretary laid out, the number of times this has happened. This is of indeed concern for the committee, and we recommend the report to our fellow committee members and members across the chamber. Thank you for your time, Presiding Officer.